Gary DeWaal here, and this is Bridging the Week for August 3rd to 7th, and today is August 10th, 2015. Good morning. Compliance officers and anti-money laundering played a prominent role in material matters impacting financial services firms last week. In two separate SEC enforcement proceedings heard in administrative forums, one chief compliance officer was only required to take additional training for his alleged law violation, while another compliance officer was not sanctioned at all despite altering documents provided to the Commission and being less than candid about her alterations. Separately, Promontory Financial Group was penalized by a New York regulator for its role in assessing AML violations by a client, while the National Futures Association fined a CFTC-registered introducing broker for not following technical rules to have its AML program independently assessed once each year, and for not timely training all of its registered employees in AML matters. As you might tell, we have a lot of individual disparate stories to cover this week, so let's get started. The New York State Department of Financial Services claimed that Promontory Financial Group, quote, exhibited a lack of independent judgment, end of quote, in connection with its review of Standard Chartered Bank's compliance with anti-money laundering requirements. The department also claimed that certain testimony by Promontory witnesses during the course of the department's investigation into the firm's conduct, quote, lacked credibility, end of quote. Promontory was retained by Standard Chartered Bank in 2010 after the bank reported to various regulators, including the New York State Banking Department, that from at least 2001 through 2007, it had engaged in conduct related to the evasion of sanctions against certain foreign nationals designated by the Office of Foreign Asset Control of the United States Department of Treasury as bad guys. The New York State Department of Financial Services claimed it relied on Promontory's review of Standard Chartered Bank in assessing the bank's conduct for the purpose of assessing a penalty in 2012. Because of Promontory's conduct, the department said it would deny all requests to provide the firm with confidential supervisory information, quote-unquote, until further notice. No monetary penalty was assessed. Promontory said it will seek a court stay of the New York State Department of Financial Services action against it, quote, and defend itself against this regulatory overreach, end of quote. One chief compliance officer was required to take training in connection with an enforcement action before the Securities Exchange Commission, while in another, unrelated action, another compliance officer was let off with no sanction despite being found to have alternate documents submitted to the SEC and subsequent lying about her actions. In the first case involving Parallax Investments LLC, an SEC-registered investment advisor, the SEC found that from at least January 2009 through November 2011, contrary to applicable rules, the firm engaged in at least 2,000 securities transactions with advisory clients on a principal basis through an affiliated broker-dealer without prior written disclosure or obtaining consent from such clients. The SEC also found that Parallax, contrary to rules, failed to provide pooled investment vehicle investors with audited financial statements on a timely basis, failed to adopt, implement, and annual review policy and procedures reasonably designed to prevent violation of applicable law, and failed to adopt and implement similar policy and procedures related to ethics. For these offenses, Parallax and John Bott, the firm's owner and manager, were jointly ordered to reimburse certain advisory clients an aggregate amount of $450,000 US and to undertake certain undertakings. In addition, F. Robert Falkenberg, the firm's chief compliance officer, was held to have aided and abetted each of the firm's violations, except those related to Parallax principal trading. Among other evidence of Mr. Falkenberg's wrongful conduct, the SEC found that he backdated evidence of an alleged review of the firm's compliance policy and procedures for 2010 that he in fact prepared ultimately only after requested to provide evidence of such review by SEC staff in connection with a routine examination of Parallax in 2011. As a penalty, Mr. Falken was ordered to take 30 hours of relevant compliance training. That's all. Separately, Judy Wolf was a compliance consultant to Wells Fargo Advisors, LLC, and in 2010 reviewed the trading of Walter da Silva Prado Neto, a registered salesperson for the firm. The SEC later sued Prado for insider trading. In December 2012, Ms. Wolf altered a document she previously prepared evidencing her review of Mr. Prado's trading. Sometime later, she changed the document to make it appear her review was more thorough and failed to disclose this alteration when the document was produced to the SEC. Later, the SEC filed charges against Ms. Wolf, claiming that she aided and abetted Wells Fargo's violation of securities laws, namely its failure to produce accurate records from an SEC representative and the firm's production of altered records. The ALJ hearing this matter concluded that the SEC's Division of Enforcement, quote, satisfied its burden of showing that Ms. Wolf acted with scienter and rendered substantial assistance in the commissions of Wells Fargo's primary violation, end of quote. However, the ALJ refused to impose sanctions on Ms. Wolf, claiming that, quote, there is a real risk that excessive focus on violations by compliance personnel will discourage competent persons from going into compliance and thereby undermine the purpose of compliance programs in general, end of quote. It would discourage people from entering compliance if a sanction occurred against someone for altering documents provided to the SEC? That's odd. In two separate cases, federal courts in New York and Georgia rejected efforts by the Securities and Exchange Commission to stop respondents subject to enforcement actions before administrative law judges from challenging the validity of such form choice. The case in Georgia involved Gray Financial Group. There, the plaintiff sought to enjoin the SEC from proceeding with an enforcement case against it in an administrative law tribunal. The case in New York involved Barbara Duca. There, the SEC likewise moved to dismiss a complaint filed Ms. Duca that sought to stop the SEC from proceeding in an enforcement action against her in an administrative forum. In both cases, the plaintiffs argued that the appointment of the relevant administrative law judge violated the Appointments Clause of the U.S. Constitution. This is because, claim plaintiffs, ALJs are so-called quote-unquote inferior officers under the U.S. Constitution as they exercise significant authority pursuant to the laws of the United States and can be appointed solely by the President alone in courts of law or in the heads of departments. Since the SEC commissioners themselves did not appoint the relevant ALJs, the appointment clause was violated, claimed the plaintiffs. In both cases, the court ruled that since it was likely that plaintiffs would ultimately prevail with their arguments, by not halting their minutes proceedings now, they would be irreparably harmed. And finally, DM Fiala, DMF, an introducing broker registered with the Commodity Futures Trading Commission, settled an administrative complaint filed by the National Futures Association for alleged violations of NFA rules in connection with the firm's anti-money laundering program. NFA charged that DMF failed to complete on a timely basis its NFA-required independent review of the adequacy of its AML program for 2013, and likewise failed to provide AML trading on a timely basis as required by NFA rules to all its registered associated persons for 2014. DMF agreed to settle this matter by payment of a $15,000 fine to NFA. NFA claimed that it had discussed with DMF its late 2011 annual AML audit and that the firm was also late in completing its 2007 AML audit. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, this is Gary DeWaal. Have a great week and ciao.